Good evening. Welcome to the webinar. Tonight our webinar is about testamentary trusts, what they are and their benefits, really the pros and cons. So I'm just going to wait a minute or two to allow people to get on or log in to the webinar. While I'm sharing my screen so you can see the slides, I can't see the question and answer or the questions that you might post. So as we go along, if you have questions, please pop them in the question box or email them to me and I will answer them and have a look at the end or get back to you after the webinar. So as I said, just waiting another minute or so and then we'll get into it. So the topic is testamentary trusts. Now, a trust is an interesting legal concept that's arisen over, close to 1,000 years. And all sorts of trusts have developed. Basically, a trust is a legal arrangement between one person who holds assets for someone else, essentially. And they've become more and more complex depending on the type that there is. Now, then testamentary is anything that's created by will. So you can have testamentary legacies, testamentary gifts, testamentary directions. So these are testamentary trusts. But before I go on too much, I should introduce myself. My name's Jacqui Brauman. I'm the owner of TBA Law and the main solicitor. And I'm also an accredited wills and estate specialist. That little logo on the bottom of the screen there is from the Law Institute of Victoria. So after I'd practiced for a while, I decided to go deep into wills and estate planning, primarily because I'd seen some horror stories with estate disputes, and I knew that prevention is better than a cure. So I think that doing your estate planning right in the first place is the most important piece. So I went on and did my master's degree, and after doing that, I did a 12-month accreditation process with the Law Institute. So there's only about 80 of us in Victoria out of about 22,000 lawyers that have this accreditation. And on the other bottom corner, because as well as being a lawyer, I'm a human as well, I'm a person. And so you can see my husband there and my blue heeler. We've got an 8-metre boat, and on that trip we were at Eildon in the spring, I think, of 2018. So Eildon was pretty full at that stage, and so we just went for a night of fishing. So yeah, everyone's got to have something to get away from work with, but we will continue. So as I was saying, I find that estate planning is really my passion area, because if it's done right, it saves people money, it saves relationships, and even more than saving people from having a mess, if it's done really well, it can actually be a huge financial benefit. Estate planning has also changed dramatically over the last 50 years or so. Estate planning used to be, the extent of it used to be a simple will. But that's because, 50 years ago, excuse me, people's lives were very different. So they didn't have compulsory super. Their blended families weren't as prevalent. People usually didn't have multiple investment properties or family trusts. They lived the Australian dream, worked all their lives, lived on the pension until they died in their 70s and owned a home. And so life was simple. But the more and more complex life gets, the more complex estate planning gets, because we've got to deal with what we're creating in our lives. And hence this poker chip that you can see on the screen at the moment are what I think the crucial aspects of estate planning are. So we've got to look at the ownership of property. So what you own, how you own it, and who owns it. So is it owned jointly? Is it owned in another entity? Is it owned jointly, or is it owned as tenants in common? So there's all sorts of things that we look at. Wills are still an important element. Enduring powers of attorney and appointing medical treatment decision makers and having advanced healthcare directives are all very important these days as well, because people are less and less likely to die suddenly. There's more likely these days to be a prolonged period of illness or decline. Superannuation, for many people, it's one of their biggest assets. It's not covered by your will, so we do have to make sure that we get the super where you want it to go. Testamentary trusts are important to think about, and that's mainly what we're talking about today. Making sure you've got sufficient life insurance and potentially permanent disability insurance. If you've got young children, you need to have instructions to your guardians, as well as appointing guardians in your will and having people under your power of attorney who can take care of your dependents. How about leaving some instructions so that they actually know what you want? Family trusts. So a lot of people have a family trust or some kind of investment trust while they're alive. These also aren't covered by your will. We have to make sure the control passes to the right person so that the assets you've collected in there will be distributed correctly. A list of personal effects is sometimes important to people as well, particularly heirlooms and instructions about what you want done with things, and then memorial instructions. For some people, this is very important as well. So these are the main elements that I find need to be dealt with estate planning. So getting more specific now into trusts. So let's consider some of the types of trusts. So I've already said that a trust is a type of legal entity or a legal relationship that forms an entity. Now you can have what's called an inter vivos trust, which is created while you're alive, or you can have a trust that's created on your death, and it's created by the gifts and the way you leave it in your will, so it's testamentary. So those are two broad categories of trusts. And then under each of those types, you've got multiple other types of trusts. So before, when we were, very tired tonight, when we were looking at the poker chip, I spoke about family trusts. So a family trust is a kind of inter vivos trust that you might set up while you're alive. So a lot of family businesses run through a family trust, or a lot of people who own investment properties own them in a family trust. So there are benefits of a family as they accumulate wealth to benefit their children and their grandchildren ultimately. And quite often farmers also own a lot of their land in a farming family trust. And this in some ways helps with succession, because the farmer can control who ends up taking over the trust instead of all the land being split up through a will. So there are pros and cons depending on the family and depending on what the purpose of the trust is. Other kinds of trusts that you can have set up while you're alive are unit trusts or fixed trusts. So if you were running a business as like in a partnership with other people, but not relatives, you might want to each own a specific percentage of the business. So you can own a certain number of units in a unit trust, and the business is run through the trust, and then what you own and therefore, what income you get when there's profit, what percentage is based on the number of units that you have. And it's a kind of fixed trust. So a fixed trust is where the beneficiaries have a fixed percentage of the trust allocated to them. That's opposed to a family trust. So a family trust is usually discretionary. And the reason why discretionary trusts used to be so popular with accountants is that there was really good tax benefits for having a trust, particularly with income splitting, because you could split income out to all sorts of people. It wasn't based on percentage. You could make the decision different from year to year depending on who had low income, top them up and make sure you don't give income to high income earners. So yeah, you can see it can get fairly complex. So testamentary trusts can be as simple or as complex as you want as well. So there's a number of different types of testamentary trusts. The most common is a minor's trust. So if you leave assets to someone who's under 18, it's automatically got to be held on trust for them until they reach 18. So that automatically creates a trust. So your executors would be the trustees of the trust. They would hold the money or the asset on behalf of the beneficiary, which would be the minor child, until the child gets to 18, and then the trust would end and the asset would transfer to that child. With a minor's trust, you don't have to have it end at 18. Most people extend it out to 21, 25 or 30. Those are usually the most popular ages. And a minor's trust is the most popular kind of testamentary trust. There are other kinds of testamentary trust like a life interest. It's a kind of a trust. So it's common in a blended family situation where husband and wife are on their second marriage. Wife owned the home from after the split with the first husband, so she wants the home to go directly to her kids, but she wants her new husband to be able to live in the house for as long as he wants. So it's a type of trust that's created where the house is held for the husband to live in it. So it's not something that will ever be transferred to him, but it's a benefit that's being held on trust for him to use it for as long as he likes. And then once he gives up that interest, so whether he gives it up because he moves on or whether he dies, then the trust ends and the house gets transferred to the children of the wife. So it guarantees that the house will ultimately go where she wants it to go, whereas if she left the house to her second husband, he might end up having a new girlfriend and then leaving the house to her if he owned it outright. But in the case of a trust, he doesn't. So that's another interesting kind of trust. Other situations where trusts arise are where there's a disabled or a vulnerable beneficiary. So where there's a beneficiary, for example, who has a mental illness, you might not want that beneficiary to get their inheritance outright. So you might create something that's called a protective trust. So they get their inheritance. So for example, $250,000 could be the inheritance for this mentally ill beneficiary, but the executors have to hold the $250,000 for that beneficiary for their whole life. So the beneficiary will never actually have the money to spend themselves. And then there's directions around the trust. So The executors have to use it for the accommodation of the beneficiary and making sure that they have their basic needs met, for example. Sometimes the trust can be so restricted that you can't dip into the capital, so the 250,000 is always protected, and it's only any income that's earned on the investment of the 250,000 that can be used for the benefit of the beneficiary. Now you can see that interest at the moment would not be very much on 250,000, so it might not be enough really. Another kind of trust that you can set up for someone who's disabled is a special disability trust. Now, this is a special kind of trust because it's got to be endorsed by Centrelink. So you'd set it up for someone who's on a disability pension, who essentially has difficulty living living unsupported. So they have to be quite disabled, and you can have about 450,000 in one of these trusts, and the benefit of this sort of trust is that Centrelink doesn't count it as an asset. So if you leave an inheritance to a disabled beneficiary, they're not going to be cut off their pension for getting a lump sum. There's other regulations around setting one of those up, as you'd understand, with Centrelink being involved, but that's the basic idea. And then finally, what most people are referring to when they say a testamentary trust, even though all of these types of trusts are testamentary trusts because they're set up in a will, when people talk about a testamentary trust, they usually mean a testamentary discretionary trust. So it's like setting up a family trust in your will. So it's flexible, it's discretionary, it's beneficial for anyone. There are asset protection benefits, there are tax benefits. So those are the main reasons it's set up. For example, asset protection wise, if someone is worried about the relationship that a beneficiary is in, they might want to leave the inheritance to the person in a testamentary trust because it's less likely to form part of a property pool in a financial settlement if that beneficiary separates from their spouse. So you can protect your hard-earned money from ending up in the hands or being divided up after a divorce. And one of the other benefits is tax benefits. So a lot of the tax benefits that accountants used to love around family trusts set up while you're alive have been wound back. However, they still exist in the testamentary trust form. So it's your only chance to set up one of these flexible tax beneficially structured trusts is in your will. So, moving on to asset protection. As I said, when you leave your inheritance, if, for example, you have 2 kids and you leave your estate equally to your 2 kids, you can leave it to each of them in a trust each. They would end up being the trustee of their own trust, and it's like they're inheriting an investment vehicle instead of cash in their hand. So you're giving them a future pool of investment, basically. And as I said, it would protect that pool of investment from being split up between a spouse in the case of divorce, because it's not cash that is theirs to use. It's not in their account. It's not in their name. It's in the trust. So at worst, it would be considered a financial resource of your child. So it would be counted as something they have. So they'd get less of the property pool that they and their spouse had built up, because they have this other pool of resources, but it wouldn't be split up between the two people if they were separating. And the other asset protection is that if your child, so if you're leaving your estate equally to your two kids, and one of those kids is, in business for themselves, leaving their inheritance to them in a trust protects their inheritance from the potential of bankruptcy or insolvency. So small business owners are at risk that if something goes wrong, their personal assets can be attacked, or if they're sued for some kind of negligence claim through their business, again, they could be attacked personally. But because their inheritance has gone into a trust, it's not in their name, it's not open to be attacked. So even if they're at risk of losing their house, they're not at risk of losing their inheritance. And as I said, the other benefit is for tax purposes. So I'll just elaborate a little bit more. Most of you understand that we work in Australia on a marginal tax system. So if you only earn $18,000 or less during the year, you don't pay any tax. Then the next tier, I can't remember what it is, 30 odd something $1,000, you pay a low rate of tax. The next tier, you pay a higher rate. And so it's a tiered or marginal scheme. If you set up a family trust while you're alive, so an inter vivus trust, and you try and split the income out to children who are under 18, you get penalised for doing that. But if it's a testamentary trust, you can split income out to minor children without penalties on marginal rates. So again, if you leave inheritance to your two kids equally, and one of your kids has 3 children in primary school, they invest their inheritance, and say they invest fairly well, and there's about $80,000 of income in their trust every year. So they don't necessarily want to pay tax on the $80,000. So they've got 3 kids. They can pull $18,000 out each year in the name of each of their children tax-free, because their kids don't have any other income. So that saves them a significant amount of tax. So that is how the tax benefit works. Some other things that people regularly ask me about testamentary trusts is how much you would need in your estate to make setting up a testamentary trust worthwhile. So like I was saying before, if you've got $250,000 and you're investing that, you're not really going to get a huge amount of interest as income. But I usually think that $250,000 to $300,000 is about the lower threshold to setting up a testamentary trust. I do sort of think that once you get into that stage, it's probably worthwhile. There's no ongoing fees on the testamentary trust until you die. So you put it in your will that you want it set up, but it's not actually set up until you pass away. So that triggers the trust. And then once it is set up, the only ongoing expenses are the fees on whatever account you put the funds in, or a managed fund, or whatever fees people charge on that, as well as an extra tax return a year. And so that tax return, because it's a bit more complex than a personal return, might be about $2,000 a year. So those are the sort of fees that you're looking at. So if you were really nutting it out, you'd want your $250,000 that you're leaving in a trust to be able to earn at least the $2,000 that's going to pay the tax return, yeah? So that's sort of how I justify how much I think should be worth going into a trust. Now, what's the process? So setting up a testamentary trust is just the same as doing estate planning with us. So we have a 5-step process to do our estate planning. It's 2 appointments for you. We prep you by sending you some information prior. At our first appointment, we collect all the information from you. Between appointments, we draft everything, and if there's some information you didn't have when we met you at the first appointment, we get that from you in between, so that when you come back for your second appointment, you sign everything and it's all done, ready to go. It takes about 2 or 3 weeks, and we're delivering the final plan to you with valid documents and trust set up and superannuation taken care of and all of that done. So what does it cost? Now, this is not our package to actually do the whole estate planning. If you only want a family situation review with us, that's to sit down with us for roughly an hour to go through your existing documents and what your family situation is, to see whether we'd even recommend a testamentary trust for you. We can do that for you. It costs $450, although if you mention that you watch this webinar, or if you book through the website, you'll get that for only $295. If you decide to go ahead with one of our family legacy plan packages and actually do your estate planning with us, that $295 gets rolled into the price of the package. And the package is usually around $1,000. $1,000 to $1,500, I should say, will get you a full estate plan with testamentary trusts done. So it is less than the cost of your annual house and contents insurance, which you pay every single year, and your estate planning, we look to make sure it covers at least 5 years, but I often say to people it'll probably last 20. So please give our office a call or go to that website, book a family situation review, or email us to lock in your $295 appointment. Now be aware that we're usually booked out about 2 weeks in advance. So we're come to the end. About half an hour. I want to say thank you. Thanks for sticking with me. I know that I talk sort of quickly, and I know that the information was quite dense, but it is an important topic if you're doing your research about testamentary trusts, to work out whether you think it's worthwhile for your situation or not, particularly if you've got beneficiaries that don't manage their money so well, or that are in a controlling relationship, or even that are a little bit more vulnerable than usual. Again, if you had a quick question rising from this webinar, you're quite welcome to ask that question, and I will get back to you, and that, so long as it's not too specific or detailed, will be complimentary. So I am going to end the slideshow and have a look to see if any Q&As have been typed in. And otherwise, I wish you a lovely evening, and happy estate planning. Thank you again. My name was Jacqui Brauman, and hope to hear from you soon.